Hello, I'm Pat Quinlan, and I'm a lawyer here at the Searcy Denny Law Firm. Today I'm here to speak with you about a threat that is all too real, something that is quietly sneaking up on us, and before we know it, could change our great state of Florida forever. The people who founded our country, and those who then wrote the Florida Constitution, were very afraid of some small group of people gaining too much power and using that power to control our government and the fate of we, the people. So our state and federal constitutions include what we call the balance of power, or separation of powers, structures and systems that prevent a single group from gaining exclusive power over our government. As you can imagine, there are those who want to consolidate and grab exclusive power. So what is it that prevents an imbalance of power? Well, there are checks and balances built into the constitutions. Think, for example, about how laws are passed and applied. The legislature can write and pass bills, but the executive branch, the president in Washington, or the governor in Tallahassee, must sign them into law, or he may veto a bill, which means he refuses to make it law. If a bill is signed into law, it then becomes the job of the judicial branch to interpret that law and apply it fairly to parties involved in lawsuits. Judges must make sure that a law complies with the Constitution and with other laws and prior court decisions. In this job, judges are supposed to act as neutral arbitrators or referees to make sure that the system operates fairly. Under our Florida Constitution, we do not elect our Supreme Court justices. They are appointed by a governor and then serve for 6 years before they must appear before voters for what is called merit retention. There is no opponent running against the justice. The voters are simply asked whether a given justice should be allowed to remain on the bench or not. Traditionally, if a Supreme Court justice has served faithfully, has not committed any crimes, and is of good moral character, voters have retained him or her on the bench. So our Supreme Court justices do not run for office like politicians. By the rules of judicial conduct, they are not permitted to discuss why they rendered certain decisions and cannot talk about upcoming cases. Most judges feel it is unseemly to campaign like politicians running for the legislature or for governor. Politics and political agendas really have no place in our system of justice. Why? Well, let's look at a what if. What if politics were allowed to influence the outcome of our most important cases, such as Brown versus Board of Education? In that case, the United States Supreme Court held that it was unconstitutional to segregate public schools into whites-only and blacks-only schools. At that time, in 1954, the Supreme Court's decision was very unpopular. Politicians, especially down here in the South, railed against the decision to desegregate the school system. Had politics been allowed to play a role in the court's decision-making process, the outcome of Brown versus Board of Education and the entire civil rights movement in this country may have been very different. That's what can happen if political parties are able to influence the judicial branch of government for their own benefit. And that is what people are trying to do here in Florida as we speak. Special interests are beginning a political campaign to unseat 3 prominent and very competent justices from our Florida Supreme Court. Why? Is it because these justices lack the legal training or the intelligence to serve on the Florida Supreme Court? No. These 3 justices, Justice Barbara Pariente, Justice Fred Lewis, and Justice Peggy Quince, were outstanding lawyers who made a mark in the legal profession and earned their places on the court. And since being appointed to the Florida Supreme Court, Justices Pariente, Lewis, and Quince have distinguished themselves as 3 of the most competent, ethical, and thoughtful justices who have ever sat on our Supreme Court. So why do special interest groups like Restore Justice 2012 or political activists within the Tea Party want to convince voters to not retain these fine justices? It is about power and influence, and it is as simple as that. If these 3 qualified justices are removed from the court, Rick Scott, a Tea Party Republican, will be permitted to appoint 3 people of his choosing as their replacements. This would secure for Mr. Scott's party, a single political party, control of every branch of Florida government. The executive, the legislative, and now the judicial branches would all be controlled by Republicans and Tea Partiers. But here's the thing. It doesn't matter whether you're a Republican, a Democrat, or an independent. Putting politics in the judicial branch and upsetting the balance of power upon which our government is based hurts every citizen. It is exactly what our founding fathers did not want to see happen. Do not allow yourself to be swayed by propaganda and misleading ads that will be produced by special interests with big money behind them. Before you go to the polls in November, I encourage you to read about Justices Pariente, Lewis, and Quince. Educate yourself about the background, the character, and the work ethic of each of them. I'm confident that you will decide that all three should be retained on the Florida Supreme Court. If nothing else, you can call me. I'd be happy to answer your questions, and my law firm can provide you with sources of information. Thank you for your time.